You're listening to A State of the Union, Estate Planning Made Simple. Here's your host, Brad Wiewel, from the Wiewel Law Firm in Austin, Texas.
Hi, this is Brad Wiewel with Texas Trust Law. This is the Estate of the Union, our podcast. And with the State of the Union, we try to get information to you that we hope you'll like, you'll be fascinated with, you'll be interested in, and you'll share with other people. We've done a number of podcasts, and we do a lot of stuff here at our law firm, again, to continue to educate clients and other people who we interact with, sometimes advisors, other attorneys. And we send out a blog every week. And what we thought we'd do for the next several weeks here with our podcast is do what's called kind of a greatest hits. And Wade Williams, who sends out our blog, keeps track of how many people click on it and what they like the most. And so we got kind of a compilation of the greatest hits here. And I'm going to start with this podcast with the number one largest blog post that people opened, and it's about mistitling assets. Mistitling assets. Now, what the heck is that? Let me kind of tell you how an estate plan works. And the way an estate plan works is it works like a water filter, all right? So if I have a water filter and I've got a source of dirty water, and I run the water through the pipe and I turn on the tap and there's no water filter, I get dirty water. If I've got a water filter and I run the water from the dirty source of dirty water through the water filter and then I turn on my tap, I get clean water. That's kind of the theory on how an estate plan works. It's not just having a will, and it's certainly not just about having a revocable living trust. You need to make sure your assets are coordinated with this estate plan so that the estate plan works. And so many times the estate plan doesn't work, and the fault doesn't lie with the document, or even perhaps the lawyer who did the document. The fault lies with the client. Because the attorney, if they're certainly a qualified attorney, a lawyer who does this estate planning for a living, not just kind of as a sideline, should have provided the client, with instructions on how to actually coordinate your assets with the plan. And if you work with us, then we actually do quite a few things, a video, and sometimes we can provide some other help to get those assets coordinated with the trust. So when we turn on the tap, we get clean water. So let's go back to how these darn things work in the first place. Everybody thinks that if I have a will and I go to an attorney and do my will, or if I do a revocable living trust, that my assets are going to go to the people that I love the way the will says, the way the trust says. And unfortunately, guys and girls, to quote Porgy and Bess, it ain't necessarily so. The only assets that go through your will to your loved ones are assets that are titled in your name and maybe titled in your name with your spouse. Those are the only assets that go through your will unless you coordinate the other assets with your will. If you have a revocable living trust, the only assets that go through the trust to your loved ones are those that are titled in the name of the trust. Now, I'll get back to trust here in a minute because I want to talk about something called a pour-over will, but let's just stick with wills. Because what I'm going to tell you about wills also applies to trusts. And the problem, guys and girls, is that the largest asset that you've got, maybe a couple of the largest assets you have, retirement accounts and life insurance, they don't go through a will, they don't go through a trust, they go to the beneficiary. So we have a number of people, of course, who come in here weekly and they've got, let's say, kids, and they want to make sure their kids get their assets when they die. If they're minor kids, then, we can put in, kids don't get the money till they're 25, they don't get till they're 30, until they're that age. It's managed by somebody, and we do that in our trusts as well. But if you have as the beneficiary on your IRA, your 401k, your life insurance, that child, and you die, that child gets the money regardless of what you said in your will, how they get it. In other words, to be blunt, if you've got a minor child and you put the minor child down as the direct beneficiary, maybe you're married, well, my spouse is the contingent, I'll put the kids my spouse is primary, I'll put the kids as a contingent. Great. What could go wrong? You die, your spouse dies, those kids get the money. Now, if they're minors, they can't manage money. The law won't let them manage money. It goes into a guardianship. And frankly, lawyers feed off that money until your child or grandchild or whoever it is turns 18. And then when they turn 18, regardless again of what your will or your revocable living trust says, they turn 18, they go to the courthouse, here's my driver's license, I'm 18, and the court will write them a check for the entire amount, regardless of what you said in your trust or what you said in your will. That's probably not a good idea. I mean, I wasn't an epitome of maturity at 18. I'm sure many of you were. I was not. And if I had access to just $100,000, let alone retirement accounts that have multiple hundreds of thousands of dollars, millions of dollars in them, it would have been disaster, ruin, and perhaps my own death. So you have got to coordinate the assets with the plan, all right? And again, if you work with us, we'll give you the exact language on how to do that. And if you work with another attorney, well, ask them for the exact language. How do I coordinate these assets, these retirement accounts and life insurance and annuities, frankly, fall into the same category. How do I coordinate those to make sure all that money goes to my family the way I want them to and not the way I don't want them to? And if you've got a special needs beneficiary, holy cow, and they inherit, because you put their name down, they can get disqualified from all their benefits. It can be a disaster. Okay, so you don't want a disaster. We don't want a disaster. Coordinating these assets, getting the dirty water through the water filter, and then to the tap is the key to success with an estate plan. Not just the words, but the assets. Now, if you have a revocable living trust, the way a trust works, and people get trust because they want to avoid probate, and there's other good reasons, but that's the primary reason. I want to avoid probate. Great. What probate is the process where somebody's died and their name is on an asset. And we have to go to court and get the dead person's name off the asset and retitled in the name of their heir. And when you do a will, you're going to go through probate because we have to get your name off and get the heir's name on, and that's what probate courts do. But some people want to avoid probate, and we're not going to go into the reasons for that right now. But if you have a revocable living trust, here's an example of a trust. Your assets aren't in your name, they're in the name of the trust. If my name isn't on it, my assets are in fact in the name of my revocable living trust, and I die, my family doesn't have to do a probate on my estate because they don't have to go to court and get my name off anything. My name isn't on it. It's in the name of my trust. And so the way you avoid probate with the revocable living trust is all the assets you've got except retirement accounts, life insurance, annuities, and a few more, maybe stock options and cars. But the bulk of what you've got isn't in your name, it's in the name of the trust. And that's how they work. Well, great. Brad, what's the problem? The problem is people don't get their assets off they're out of their own names and in the name of the trust. They go to the lawyer, they get the trust, the lawyer gives them instructions, and they go home and they don't do it. Now again, we have a process here that helps some of our clients. If you want information about that, you can let us know. But it's a problem. So when you do a trust, this is kind of interesting, you get a little will. So if you've left an account out of the trust, it's in your name and you die, guess what? We got to do a probate. We have to do a probate to get this asset out of your name and into the name of your trust. When you do a trust, you get a special kind of will. I call it a backstop will. The actual term is a pour-over will. So this little will you get acts like a backstop in a baseball game. The ball gets by the catcher and it hits the backstop. The catcher goes back, gets the ball, and throws it back into play. Now all the assets are back in the trust. The pour over will, the concept of pour over will, it says if you left something out, those assets gets poured into the trust. So ultimately then the assets go to your family the way you want them to get it. And they get it, and everybody's happy, and we're singing Kumbaya, right? Except what? Except retirement accounts, life insurance, annuities, okay? Those you can't put in the name of the. You could maybe technically do life insurance and annuities, but it's hard to do and very rarely done. Retirement accounts, again, you can't put a retirement account in the name of a revocable living trust. You cannot. You can only use a beneficiary. So again, part of this process of making this estate plan work is making sure, even if you have a revocable living trust, that the beneficiary designations on your retirement accounts, on your life insurance, on your annuities are lined up with this trust. And again, for our clients, we give them the exact language to use. They can get with their advisor and get that done. Again, if you're using a qualified lawyer for your estate planning needs, they should be able to give you and should have already given you perhaps the exact language you're going to need to give to your advisor or to go online. If you work with a company, you go online, you make the change. So it's not hard to do this, but you have to do it. If you want all the assets in the bowl, if you want to make sure your family gets your money the way you want them to get it, when you want them to get it, then you've got to make sure, not just if you have a trust, but also if you have a will, that the assets you've got are coordinated with that, and all the money you've got is going to go to those you love the way you want them to get it. And frankly, that's how you're showing your love. Nothing falls through a crack. Nobody gets it too soon. Nobody gets it too late. Everybody gets it on time, and they miss you. And you did such a great job of your estate plan. Boy, Mom and Dad really did a great job. That's nice to hear when people can. Mom and Dad did a great job of their estate. So much easier than we expected. Do that, okay? A quick aside, we've written 5 books in our practice, and you can go on our website, Texas Trust Law, and download those. We've also, I just finished writing a little daily devotional. This is a Hard Days devotional, Blessings for Bruised Boomers. And I'm a baby boomer. Probably couldn't tell. And quite frankly, I'm a little bruised. I think anybody who's lived a while is bruised. And this is just a little daily reading about something. I went through the Bible and pulled out all the verses that say blessing, blessed, or bless. And I wrote a little thing on it. It's short. It's kind of pithy. You can go to Amazon and buy one. And in fact, Christmas is coming up, so they make a nice little gift, because it's hard to buy gifts for baby boomers because we already have everything. So if you're looking for something to give somebody, check out our book, Hard Days Devotional, Blessings for Bruised Boomers. Thanks. We'll be back again with another edition of the Estate of the Union. Have a great day.